Hello, and welcome to another episode of the Legal Lowdown. I am your host, Matthew R. Carpenter, an attorney, and today we are looking at a rather interesting Stanford Law Review article titled The Pardon Power and Federal Sentence Reduction Motions by Jaden Lesnick. It tackles a really big question about power in the federal government, specifically the power of courts to potentially shorten federal prison sentences after they've already started, sometimes called compassionate release, though the essay gets into why that label might be a bit tricky. So the mission here is to understand the debate that's brewing, according to this essay. Does this judicial power to grant compassionate release clash with the president's own constitutional power? You know, the power to grant pardons? That's the core tension. So let's look at the first argument. The source material points to figures like Ohio Attorney General Dave Yost and former Ohio Solicitor General Benjamin Flowers. So their argument, as laid out in the source material anyway, is that courts allowing them to reduce sentences under 18 U.S.C. 3582 C1A is actually unconstitutional. For those of you who don't know, that is the compassionate release statute that was implemented through the First Step Act. So the critics, Yost and Flowers, say that this statute gives judges a power that the Constitution sets aside only for the president. That is the power of commutation, sentence reduction, reducing the sentence, often seen as an act of mercy, right? But this argument to me sounds similar to another issue that has been brought up, in my opinion. Some critics of big government say that Congress is only allowed to incriminate certain crimes, right, that are specifically identified in the Constitution. So Article 1, Section 9 lays out 3 to 4 crimes that Congress is specifically authorized to criminalize and regulate. And that hasn't really been the case, though. I think, as the source material even pointed out, there's something like almost 5,000 federal crimes out there, right? There's far more than the 4 crimes that are authorized by the Constitution. So, what happened, right? Well, the reality is that judges and interpreters read other parts of the Constitution, and they said that those other parts of the Constitution expanded Congress's power, like the necessary and proper clause, for example. And so this is one ground on which judges have said that Congress has the ability to criminalize more than just those 3 or 4 illuminated offenses. And so this is typically the case, right? Like, Congress exceeds its illuminated authority all the time. If you've gone to law school, you understand that, right? And so that's the point. But anyway, Ohio AG Yost and ex-Ohio Solicitor Benjamin Flowers are saying that Congress took a presidential power and just handed it over to the courts, basically. They see compassionate release as presenting 2 issues. It potentially violates the separation of powers doctrine, and they say it could violate the unitary executive power, right? They literally call compassionate release, they call it judicial sentence reduction, a commutation by another name, basically. So that's one side of it. But the Stanford Law Review article that we're looking at puts forth another. It calls the challenge brought by AG Yost and Solicitor Flowers, and I quote, dead wrong. Strong, zesty words, very zesty. So the next logical question then is, how does the essay defend this power, this judicial sentence reduction power, right? What's the rebuttal that it makes to the state officials? It makes a few key points. First, it emphasizes Congress's really broad authority over federal criminal law, meaning Congress gets to decide sentencing rule. That's what I mentioned before. But the source material also says that Congress has always created ways to address things after the initial sentence. Like, if you think about parole, for example, or supervised release, or even sentence reductions for helping prosecutors under Federal Rule of Criminal Procedure 35B, right? If you cooperate, you get a reduced sentence, and that's a federally authorized provision. So this isn't totally new territory, this idea of modifying a sentence. And are we to eliminate federal supervised release, these federal programs that support clemency? Like, is all of that going to go away? This is what the essay really argues, that invalidating this specific sentence reduction law could actually put a lot of other well-established practices at risk, right? Slippery slope type stuff. It's presented as just another form of back-end flexibility that Congress uses to govern through democratically sponsored laws. Like, compassionate release is no different than supervised release, basically. So what about the separation of powers then? Does the judicial power of compassionate release really stop the president from doing his job? Well, if you haven't guessed it, the essay argues no, not at all. It says, look, the separation of powers isn't about building rigid walls between branches, right? There could be overlap between what the judicial branch and what the legislative branch does, or between what the legislative branch and the executive branch does. Like, there can be overlap. The real constitutional test, the essay suggests, is two parts. First, does one branch's power stop another from exercising its rights? Just flat out stop them from exercising their rights. And second, does one branch's power stop another from carrying out its constitutional duties? So in other words, first, are you flat out stopping me from doing what I'm supposed to be doing? Right? And if you're not, in a more narrower sense, are you stopping me from abiding by the Constitution? Now, I haven't seen this standard specifically articulated like that in the case law, but the source material draws on cases like Trump v. Massars, which came out in 2019, and then Nixon v. Administrative General Services, which came out in 1977, and then another case from 1989 called Mistretta v. United States. And moving along here, sentence reduction doesn't really meet this two-part standard, at least that's what the source material says. Right? It doesn't stop the president from pardoning anyone, and it doesn't stop him from abiding by the Constitution, like not at all. And according to the essay, the pardon power is way broader than compassionate release or judicial sentence reduction, right? It can wipe out the presidential pardon power, that is. It can wipe out the conviction itself, not just the sentence. It can happen before someone's even convicted, right? The president can pardon someone who hasn't even been convicted as long as the crime has already been committed. And the president doesn't need specific legal reasons laid out in the statute, right? Where the judicial sentence reduction does. And it only happens, when we talk about judicial sentence reductions, it only happens post-sentencing. It only affects the time that the person is already designated to serve. And crucially, the judges need to find specific and extraordinary compelling reasons, right? They also have to consider their original sentencing factors. It's not just a free-for-all mercy button. In that phrase, extraordinary and compelling reason, laid out in the statute is actually key, in my opinion, because I've advised on dozens of compassionate release motions. And when I was actively doing this, the courts are not just willy-nilly granting these motions, right? Like, you basically have to be dying. And imprisonment has to be aggravating your condition. Like, you could live a little bit longer if you were compassionate released. And so, therefore, your compassionate release would probably be granted. Maybe, right? But anyway, the essay argues that this judicial release or compassionate release isn't just a commutation by another name. It argues that compassionate release itself could be a bit of a misleading label because the legal standard is very high, like I just said. And, I totally agree with that. Compassion, basically, only for terminally ill people is really what's going on here. And, the way that the legislation discusses it or shapes it and the way the case law shapes it, it's really framed more like a judicial safety valve for truly unforeseen serious situations that arise after sentencing. Like, you got stabbed in prison after you were sentenced and your lung collapsed and you're going to die if you get COVID. In a prison where everybody is sharing soap, everybody is sharing bunks and all that type of stuff. So you're guaranteed to get COVID. You're basically guaranteed to die. In which case the court would say, okay, we'll let you out. Okay, but anyway, moving forward. And what about this idea that only the president, being politically accountable, should, exercise mercy, right? Like, do we really only want the president to be able to fix past criminal wrongs? When we talk about the criminal justice system, how it works and how it can sometimes target people in ways that seem unethical or unfair, do we really want the president with all that he's responsible for doing on a day-to-day to be the exclusive authority on, atoning? The essay tackles that too. It points out that judges always consider various factors, right? Sometimes including elements of mercy or leniency during the initial sentencing phase. That's just part of judging, right? And there's more of the judges doing that. So the judges are going through this strenuous process. They're making sure they're looking at the record. They're giving attention to each person's case, right? Whereas when it comes down to the pardon power, I don't think the president is really doing it. I can't say that he is, but I think that most of us would probably believe that that Trump doesn't have time to be looking at everybody's record, going through the criminal history and the pre-sentence report and all that type of stuff. Like, he just doesn't. And so the argument goes, at least from the source material, if judges can exercise that kind of discretion up front in greater volume, why can't they have, limited statutorily defined power to adjust sentences later, like under specific compelling circumstances? And just taking a step back, that lays out the debate pretty clearly. And so the question, I think, is why should you, the listener, care about this legal back and forth. And to be honest, I think it really matters because it's about who holds the keys, quite literally just shortening time in federal prison. And we're seeing increasing rates of incarceration throughout our country, particularly at the federal level. And I think this debate, importantly, is a window into how our system of checks and balances is supposed to work. That tension between Congress making laws, courts applying them, and the president having this unique executive power, right? And so it touches on whether we want more flexibility within the judicial system to address specific, perhaps unforeseen individual cases, or we prefer keeping that kind of sentence reduction power, that mercy, mainly with the president, who's directly accountable to voters. And I think that's a good point, right? Like you have a Democratic elected person, whereas federal judges are appointed by life. But then that kind of gets messy because the president is democratically elected and then he appoints people. So, the president is democratically elected and then he pardons people. Like, there is a democratic element in both situations. But anyway, so, wrapping up the Stanford essay we explored, it lands firmly on the side of the statute being constitutional, obviously. It argues it's a valid use of congressional power and it's a necessary judicial tool, and absolutely not a takeover of the president's part authority. The challengers, it says, just misread the law and the Constitution. Okay, so here's a final thought for you to mull over, for you to chew on, for you to hurt your head on, whatever. Does having these multiple paths, one through the courts based on specific reasons, another through the president based on broader clemency, make the justice system ultimately more fair and adaptable? Or does it risk creating confusion, maybe even conflict about who has the final say? Just something for you to think about. Thank you for listening to this episode of The Legal Lowdown.